for the Commission for Election.
Video na yan.
Now, I represent her in the Supreme Court, but because it's pending, you will understand why.
Lalabo na siya kapag nilapitan ko pa.
But it will never stop me from stating what I think should be said anyway. But before we actually hear the position, the statement of Congresswoman Regina Reyes, perhaps Commissioner Larazaban should run through the developments in the congressional election, prompting us to call for this meeting today.
Good afternoon, everyone. We're here to discuss the facts relative to case filed against Congresswoman Reyes. Congresswoman Reyes ran as member of the House of Representatives for the Council of UK.
Todo na yun?
After she filed her COC, a case
Todo na to.
for cancellation of COC was filed against her. It was pending with the public, and before elections, a decision came out by the division. However, an appeal was an MR was recently filed at the NLAC, and a decision came out only after the elections. And the finality of that decision was only after she was proclaimed by the Provincial Board of Canvassers of the province of Marinduque. Now, jurisprudence dictates that if you file a COC and the order is not yet final, there is no reason for the suspension of the decision. After the finality of the decision, a social case was filed with the Supreme Court by Attorney Reyes. It's difficult to comment on the facts of the case, but as we've explained later, there are some things that have to be examined and re-examined. Specifically, if you look at the dissenting opinion of Comelec Chairman Brillantes and Supreme Court Justice Reyes. I will leave it to Attorney Roque and Congresswoman Reyes to further explain this.
So in the Supreme Court, we filed a petition for certiorari assailing the decision of the Comelec, saying that the Comelec, in effect, continues to have jurisdiction after her proclamation. Now, there is a dissenting opinion that I wish everyone would read. This is the case of Reyes versus Comelec. The dissenting opinion pointed out, number one, this is highly unusual, and this is the words of Justice Prior, because it was decided in haste. Upon filing of the petition, instead of asking the Comelec to comment, they came up with a decision affirming the decision of the Comelec. And Justice Prior not only described it as undue haste, but he called that his colleagues should be more careful in what they're doing, because he said it in his dissent, it will benefit one of them. And he is referring to the fact that Lord Allen Velasco is the son of Associate Justice Presbitero Velasco. Now, there is a motion for reconsideration which we will file. We have until Saturday to file it. And I'm sure that next week we will be discussing the contents of our motion for reconsideration. So, for now, I will turn over the floor to Congresswoman Regina Reyes for her statement today.
Good afternoon po sa inyong lahat. Magandang hapon po, magandang tanghali. At marami pong salamat sa pagdalo nyo sa ating pagpupulong para sa pagtanggol ng karapatan ng mamamayan ng aming mahal na lugar ng Marinduque. Ginagawa ko po ito para sa aking mga kababayan. Siyang naniniwala na ipaglalaban ko ang karapatan, kinabukasan at karangalan ng bawat Marinduqueño. I am Regina Reyes. I am a lawyer, and I am Filipino. In the last elections, I ran for the post of representative for the lone district of Marinduque. During the campaign period, my opponent, Lord Alan J. Velasco, son of Associate Justice Presbitero Velasco, procured a decision from the COMELEC, declaring my candidacy as null and void, allegedly because I am American. But because this decision was not yet final, I decided to pursue my candidacy, despite the fact that such a decision was detrimental to my campaign. Pupunta po ako sa bundok, sinasabi ng aking mga kababayan, sayang po ate at disqualified po kayo. Wala po kaming signal sa aming mga bundok sa Marinduque. Pero umiikot po ako sa aking kababayan para sabihin sa kanila at ipaliwanag na ako po ay hindi disqualified. In spite and despite that COMELEC resolution, I won the elections for the post of representative for the lone district of Marinduque, having received 52,209 votes. I had a margin of almost 4,000 votes from my closest rival, the son of Justice Velasco. I have been duly proclaimed with the Board of Canvassers on May 18, 2013. I took my oath of office before His Excellency, President Noynoy Aquino, on June 27, 2013, and before our Honorable Speaker, Feliciano Belmonte, on June 5, 2013. In addition to having taken an oath before a judge of the Regional Trial Court. I have since assumed my post as representative, having already filed my first bill, House Bill number 128, on July 1, 2013. I am therefore the duly elected representative of the people of Marinduque. Jurisprudence has always been consistent. A congressional candidate, once proclaimed, is the duly elected representative of the
Tignan mo yan sa
people.
kaliwa.
After proclamation, all disputes relating to the qualification of a member of Congress shall be resolved by the House of Representatives Electoral Tribunal. Iba po ang manang June. Alam po natin yan, i-check po. The rationale for this is twofold. One is to ensure that the Congress is a continuing body. The Constitution provides that Congress, for instance, shall convene without need of call in case of the declaration of martial law. That's why it's imperative that all members of Congress be proclaimed as soon as possible. This is why the election for members of Congress does not allow any pre-proclamation controversy. But secondly, and more importantly, once proclaimed, members of Congress are not subject to the jurisdiction of COMELEC, nor any branch of the government, including the Supreme Court. Only HREP, the House of Representatives Electoral Tribunal, can be the sole judge of all controversies involving the election of its members. This is because of the separation of powers. This is what the Philippine Constitution, our laws, and our jurisprudence provide. And yet, apparently, my election has become the lone exception to the rule. It is very clear that jurisprudence cannot be reopened unless there are changed circumstances. And yet, apparently, both the COMELEC and the Supreme Court have rewritten jurisprudence because they have effectively ruled that the son of Presbitero Velasco, whom I defeated by almost 4,000 votes, should instead sit as representative of the people of Marinduque. What, if any, is the changed circumstance warranting the reversal of jurisprudence? It is my position that there is no change of circumstance warranting the reversal of jurisprudence. Instead, what we have is one undeniable fact. That is, my opponent is the son of a sitting justice of the Supreme Court. I refer you, nandiyan po sa inyo mga, I have copies of that, copy po tayo dyan, to the dissenting opinions of Justices Brigon, Carpio, Villarama, and Yonen in the case of Reyes versus Pomenek on why Presbitero Velasco is the overriding circumstance that changed jurisprudence. This is an instance where a justice of the highest post wielded his influence to reverse jurisprudence in order to benefit his family. This is a travesty of justice. Consider the following points in the dissenting opinion of Justice Arturo Brion. May mga kopya po kayo dyan. Number 1, why was there undue haste in deciding my petition? Normally, the filing of petition would warrant an order from the court for the respondents to comment. Alam ko po yan sapagkat 10 taon po ako nasa Office of the Solicitor General. Nag-trial attorney po ako at nag-solicitor po ako sa Office of the Solicitor General. Trabaho po namin yan. Trabaho ko po ng 10 taon. The Supreme Court, despite my claim of denial of due process rights, since the COMELEC did not conduct a hearing where I could offer evidence of my citizenship. Ito po, mga kababayan. Philippine passport at mga ibang ebidensya. Hindi po ako binigyan ng pagkakataon ng COMELEC para ipakita ang aking katibayan na ako'y Pilipino. Mas matimbang pa po ang isang internet blog ng hindi kilalang tao at hindi naman humarap sa korte para maging basehan ng aking diskwalifikasyon bilang noon kandidato at ngayon representante ng aming mahal na lalawigan ng Marinduque. So, the Supreme Court, despite my claim of denial of due process rights, since the COMELEC did not conduct a hearing, alam po yan ng ating former Commissioner Gregorio Larrazabal, former COMELEC Commissioner po yan, where I could have offered evidence of my citizenship, was not even ordered to comment so it can dispute my assertion. Ito po. In its haste to rule in favor of Velasco, the court even rewrote the constitutional provision on when elected officials assume their positions. Kaya ang aking mga kaibigan dyan na kapwa-congressman, hindi pa kayo congressman ngayon, ayon kaya Justice Perez sa kanyang ponensya.